The Supreme Court just handed down an 8-1 ruling that is about to reshape the entire battlefield of the Second Amendment, and most people still don't fully understand what just happened. 8 justices agreed, 1 dissented. In a court the media constantly portrays as deeply divided, where every major decision is expected to split along bitter ideological lines, that kind of near-unanimous agreement is not just rare. It is a signal, a very loud one. This is not a minor technical decision buried in legal language that only attorneys will ever read. This is a constitutional line being drawn in a way that directly affects millions of Americans, whether they realize it yet or not. It does not matter what state you live in. It does not matter whether your governor is a Democrat or a Republican. What the Supreme Court decides becomes the law of the land for everyone, everywhere, all at once. And in just a moment, I am going to break down the real reason this 8-1 decision is so powerful, and why even the single dissent may actually strengthen what the majority just decided. Here is the part almost nobody is explaining correctly. This ruling does not just decide one case. It changes how courts across the entire country are going to evaluate gun laws moving forward. Every federal judge, every pending case, every future restriction, all of it just shifted. If you own a firearm, if you plan to own one, or if you care at all about how far the government can go in restricting constitutional rights, this decision matters to you, not theoretically, personally. For decades, the Second Amendment has existed in a strange legal space. On paper, it is clear. The right of the people to keep and bear arms shall not be infringed, but in practice, that right has been tested, limited, and quietly interpreted in ways that left enormous room for government control. Not all at once. Not in one sweeping move, but slowly. Piece by piece, through court decisions that introduced balancing tests, exceptions, and legal frameworks that each sounded reasonable in isolation, but that together created something that looked nothing like what the Constitution actually says. Most gun owners felt the erosion happening, they sensed it, but without the specific legal knowledge to name exactly what was being done and how, the quiet dismantling continued in courtrooms most people never heard of. That changes today. Every major Supreme Court ruling that truly matters starts with a real person whose real life got caught in the machinery of government overreach. And the story at the center of this case is going to make your jaw drop, because it ends with the highest court in the country telling the federal government it went too far. His name is Brian Range. Brian Range is not a violent criminal. He has never been accused of harming anyone, no history of assault. No weapons-related charges, nothing that would make you think he posed a danger to the public. What he did dates back to 1995. He filled out a food stamp application in Pennsylvania and reported his income inaccurately, lower than it actually was, so he could qualify for benefits. That was it. No elaborate scheme, no ongoing fraud operation. Just a single misrepresentation on a government form. He pleaded guilty to a misdemeanor. He paid a fine. He served 0 prison time. By every normal measure, his debt to society was paid completely and in full. But here is what happened next. And this is the part that changes everything. Because of that one guilty plea from nearly 30 years ago, the federal government told Brian Range he was permanently and completely banned from ever owning a firearm again. Not temporarily restricted, not required to jump through additional hoops. Permanently banned for life because of a non-violent, low-level paperwork offense committed 3 decades ago when he was a young man trying to get by. The law used against him is 18 U.S.C. Section 922G1, which prohibits anyone convicted of a crime punishable by more than 1 year in prison from ever possessing a firearm. His misdemeanor technically carried a maximum possible sentence of more than 1 year under Pennsylvania law, even though he received no prison time at all, and everyone involved treated it as a minor matter at the time it happened. So let that sink in for a moment. A man who falsified a government form in 1995, who paid his fine and moved on, who lived a completely law-abiding life for the next 3 decades, was told by the United States government that his Second Amendment rights were simply gone, not suspended, not limited with a path to restoration, gone forever because of a paperwork offense that landed him no jail time. Brian Range wanted to own a rifle. He wanted to be able to protect his home and his family the way millions of Americans do every single day. And the answer that came back from the government was absolute. You are a prohibited person. You cannot own a gun. Not now. Not ever. Brian Range did exactly what every American should do when the government crosses a line it cannot justify crossing. He went to court. His argument was straightforward but powerful. He did not claim all gun laws are unconstitutional. He did not argue that violent criminals should have access to firearms. Instead, he focused on something much more specific. that applying a lifetime gun ban to a non-violent individual based on a decades-old minor offense, with no path to restoration and no individualized assessment of actual danger, violated the Second Amendment, and he won 8-1 at the highest court in the land. Do you think a non-violent misdemeanor from 30 years ago should permanently cost someone their gun rights for the rest of their life? Drop your answer in the comments below right now, and smash that like button, because this information needs to reach every gun owner in America today. To understand why this ruling carries the weight that it does, you need to understand the legal framework the court used to reach its decision. This is not just about one man in Pennsylvania. This is about a legal test that now applies to every gun restriction in the entire country. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. If you own a firearm and you have not fully absorbed what that decision did to American gun law, you are missing the foundation of everything happening right now in Second Amendment litigation. Before Bruin, courts evaluated gun restrictions using what was called a means-ends balancing test. In plain language, a judge would look at a gun restriction, decide whether the government had a good enough reason for it, and weigh whether the restriction was proportionate to that reason. It sounded reasonable, but in practice, it gave judges enormous flexibility to uphold almost any gun law as long as the government offered a plausible public safety rationale, and governments are extremely skilled at offering plausible public safety rationales for almost anything they want to do. The balancing test was in practice a framework that tilted heavily toward restriction and gave gun owners very little solid constitutional ground to stand on. Bruin threw that entire framework out. After Bruin, when a court evaluates whether a gun restriction is constitutional, the government has to prove the restriction is actually consistent with the historical tradition of firearm regulation in America going back to the founding era, not consistent with what feels reasonable to a modern judge, not consistent with current policy preferences about public safety, consistent with what the founders actually did, what the legal tradition looked like in 1791 when the Second Amendment was ratified. That is a fundamentally different and far more demanding standard, and it is exactly the standard Brian Range used to fight back. Here is what the court found when it applied that test. Historically, the people who lost their right to keep arms were those deemed genuinely dangerous, those who had demonstrated a real propensity for violence, those who posed a concrete and identifiable threat to public safety. The historical record did not show a tradition of permanently stripping non-violent people of their gun rights based on minor offenses that resulted in no prison time. The government could not point to a founding-era law or practice similar enough in purpose and burden to justify what was done to Brian Range. And under the Bruin standard, if you cannot find that historical anchor, the restriction falls. 8 justices agreed. Now here's what this ruling actually means for you personally, because the mistake most people make with Supreme Court decisions is thinking they only affect the specific person in the specific case. This ruling sends a direct and powerful signal to every federal court in the country, every circuit court, every district court. Every federal judge currently sitting on a case involving the federal gun ban statute is now being forced to look at those cases through a completely different lens. The precedent has shifted. The government's ability to permanently disarm nonviolent people based on decades-old minor convictions has been dealt a serious and lasting constitutional blow. There are thousands of people across this country with old nonviolent convictions who were told they could never own a gun again. Minor fraud cases, nonviolent drug possession. Financial mistakes from decades ago. In many of these cases, the individuals served no prison time, rebuilt their lives, and have had no further issues with the law. The reasoning the court applied here, that the government must demonstrate a historical tradition of disarming this specific type of person, applies with equal or greater force to those situations. Those people now have a constitutional argument they did not clearly have before this ruling came down. Every year, thousands of firearm purchases are denied through the federal background check system. Some of those denials are entirely appropriate, but others are based on old records, unclear classifications, or offenses that fall into the same category. Nonviolent, minor, decades old. Before this ruling, challenging those denials was extremely difficult. Now the legal ground has shifted. Because those denials must be evaluated under the same historical framework, the Supreme Court just reinforced with 8 votes. That does not mean every denial will be overturned, but it does mean that some of them now face serious constitutional challenges they never had before. And beyond individual cases, this ruling creates serious constitutional headwinds for any effort to expand the categories of people who are permanently prohibited from owning firearms. Any new restriction at the federal or state level now has to survive the Bruin historical test. Lawmakers can no longer rely on broad public safety arguments alone. They have to ask whether they can point to a historical tradition that supports the restriction. And if they cannot, start, that law is now vulnerable. This changes the entire calculus for legislators and regulators who have grown accustomed to expanding gun restrictions without facing serious constitutional scrutiny. Now let's deal with the myths directly, because they are already spreading online, and acting on them without understanding the full picture could get people into serious legal trouble. The first myth is that this ruling means anyone can now own a gun regardless of their criminal history. This is dangerously wrong, and you need to reject it completely. The ruling is carefully and deliberately limited in its scope. It does not eliminate gun laws. It does not give violent offenders the right to possess firearms. It does not erase the concept of prohibited persons. What it says is that applying the federal ban to this specific type of person, a non-violent offender whose conduct does not fit the historical tradition of persons considered genuinely dangerous, was unconstitutional as applied. The government retains broad constitutional authority to prohibit violent people and people who have demonstrated a real and concrete danger to the public. That authority was not challenged here and was not touched by this ruling. Know the difference between what was actually decided and what people are claiming was decided. The second myth is that this ruling automatically restores gun rights to everyone with a nonviolent conviction. Also false, and acting on it could result in federal criminal charges. Supreme Court rulings establish constitutional principles. They do not automatically change your personal legal status. If you have a prior conviction and you believe this ruling may affect your situation, you need to speak with a licensed attorney who specializes in Second Amendment and federal firearms law before you do anything at all. Possessing a firearm while you are still legally classified as a prohibited person, even if you personally believe that classification is now unconstitutional, can result in serious federal prosecution. Use this ruling as the foundation of a legal strategy built with professional help, not as a permission slip you give yourself. The third myth is that this is just a conservative versus liberal political decision. The 8-1 vote dismantles that framing completely. If this were purely political, you would expect a narrow ideological split. Instead, you got near unanimous agreement. That tells you something critical. This decision was driven by constitutional reasoning strong enough to cross ideological lines, and that makes it far more durable moving forward. When a constitutional principle is clearly enough grounded in history and legal tradition, it pulls justices across the usual dividing lines. That near-unanimous vote is one of the most powerful aspects of this ruling because it makes it significantly harder for future courts or future administrations to quietly work around. Now step back and look at the bigger pattern, because this ruling does not stand alone. In 2008, District of Columbia versus Heller established that the Second Amendment protects an individual right. Not a collective right tied to militia service, an individual right that belongs to you personally and constitutionally. In 2010, McDonald versus City of Chicago extended that protection to every single state in the country. Before McDonald, there was still a live legal argument that Heller only applied to federal jurisdictions. McDonald closed that door permanently. In 2021, Caniglia versus Strom, decided 9-0, confirmed that police cannot use creative legal doctrines to walk into your home without a warrant and seize your legally owned firearms. In 2022, Bruin replaced the balancing test with the historical tradition test, fundamentally shifting the burden of justification onto the government and away from the gun owner. And now, 8 justices have said the federal government cannot permanently disarm a nonviolent person whose conduct does not fit the historical tradition of individuals deemed genuinely dangerous at the founding of this country. 5 major rulings, nearly 2 decades of consistent movement in the same direction. This is not a series of random outcomes. This is a constitutional framework being constructed, case by case, ruling by ruling, and the direction is unmistakable. The Second Amendment is being treated more like other fundamental rights, with stronger protection, stricter scrutiny, and far less room for broad, undefined government limitations. Most mainstream coverage has completely failed to capture what this pattern actually means for gun owners across the country. So here is what you should actually do with everything you just learned, because knowledge without action is just noise. First, take honest inventory of your own situation. If you have a prior conviction of any kind and have been told you cannot own firearms, you now have a reason to revisit that determination with qualified legal help. Not to assume you can go buy a gun tomorrow morning, but to understand whether this ruling creates a legitimate constitutional argument in your specific case. Every conviction is different. Every state's law is different. Every set of facts is different. But the legal door the Supreme Court just opened is real, and it deserves a serious conversation with a serious attorney. Second, if you have been denied a firearm purchase and believe it was based on an old, non-violent minor conviction, document everything about that denial completely. The date, the reason given, everything the dealer told you. That documentation becomes the starting point for a legal challenge that is now considerably stronger than it was before this ruling came down. Third, pay close attention to what happens in the lower federal courts over the next 12 to 18 months. This ruling is going to generate a significant wave of legal challenges to the federal prohibited person statute as applied to specific categories of nonviolent offenders. Those cases will work their way through the circuit courts, and some of them will return to the Supreme Court. The decisions coming out in the coming year will tell you exactly how far the reach of this ruling extends in practice. Here is why all of this matters beyond the legal details and the case names and vote counts. Rights do not disappear overnight. They disappear slowly, through 100 small exceptions, through 1,000 quiet workarounds, through legal doctrines that each sound reasonable in isolation, but that together add up to something that looks nothing like what the Constitution actually says. What the Supreme Court has been doing, case by case and ruling by ruling, is identifying those quiet erosions and drawing lines, restoring the constitutional baseline, not because the justices are indifferent to public safety concerns, but because the Constitution is the document that determines how we balance rights against risks in this country, and that balance has to be grounded in history and principle, not in whoever happens to hold political power at any given moment. Brian Range spent nearly 30 years unable to own a firearm to protect himself and his family, not because he was dangerous, not because he had ever threatened or hurt anyone, but because a legal system that had drifted from its constitutional foundations had classified him as permanently prohibited based on a paperwork offense from his younger years. The Supreme Court looked at that situation, applied the proper constitutional standard, and said, this is not what the Second Amendment allows. 8 justices agreed. That is what it looks like when the system actually works the way it is supposed to work. The case is United States versus Range. The vote was 8-1. The principle is now Supreme Court precedent. The federal government cannot permanently ban a nonviolent person from owning firearms when that person's conduct does not fit the historical tradition of individuals considered genuinely dangerous at the founding of this country. Know it cold. Because knowing it changes how you respond when anyone tells you your rights can be stripped away without meeting that constitutional standard. Rights are rarely lost all at once. They erode slowly. And what the Supreme Court just did is push back. Not with rhetoric, not with politics, but with a constitutional standard rooted in history. They sent a message that there are limits, that those limits matter, and that even long-standing laws can be challenged when they go beyond what the Constitution actually allows. Brian Range's case started with one person, but the impact of this ruling is just beginning. Drop a comment below and tell me whether you know anyone personally who has lost their gun rights over an old non-violent conviction. Tell me whether this ruling changes how you think about the federal prohibited person laws. Stay informed, know your rights, and never stop fighting for them.